Hello and welcome to episode 25 of The Legal Scoop, our webinar series here at LOMAD, where we talk about recent wins by our attorneys or even our staff. I'm your host, Brendan Shannon. I'm an associate attorney here at LOMAD, and I'm joined today by my colleague who needs no introduction, Melanie Daly. Say hello, Melanie.
Good morning. Thank you for having me.
Thank you for being here. Now, I understand that you had a recent win where you were able to get benefits suspended pending a fraud trial based on offer of proof. So could you just give us the basic details of that?
Correct. Yes, we had a file where a claimant denied any injuries. She testified no prior injuries to her cervical spine. She did list on the C3 that she had a prior injury to the back. However, the claim was for the neck also, and she did not list any prior treatment or symptoms to the neck. She also presented to her doctor, who both testified. There were two of them. One testified that he had no knowledge of any prior neck injuries, so she denied any prior neck injuries to that doctor, while the other doctor testified that he did in fact treat this claimant for a prior injury and symptoms to the neck.
Oh, wow. Now, did we get an ISO report in this case?
Yes, there was an ISO report which shows several motor vehicle accidents in the past, some distant, but several more recent where she did claim a cervical spine injury.
Oh, wow. So I guess the general idea that I'm assuming came into play here was that when we raise fraud and there's a fraud trial pending where we're going to take the claimant's testimony and eventually produce evidence in support of fraud after the claimant testifies, we can make an offer of proof to get benefits suspended in the interim because basically there's a risk of an overpayment because if the claimant's found to have committed fraud and there's a mandatory penalty or a discretionary penalty barring the claimant from getting future indemnity benefits, then any benefits that are paid pending the trial would not be just. They shouldn't be paid. But did something else come into play here with the ISO report?
Yes, with the ISO report, we did present that as an offer of proof. We argued that pending the additional testimony and our development of the record is retaining additional records, getting the claimant's HIPAA, going back to those car accidents and requesting those records, that her benefits should be suspended during that time.
Oh, wow.
Yes.
So
go ahead. We did offer make the offer of proof, the ISO, and the judge directed memorandum of law based on whether or not an ISO was sufficient to make that offer of proof to suspend benefits pending that development of the record.
Okay, and based on our conversation beforehand, you found that while an ISO in and of itself might not be enough to get benefits suspended pending the fraud trial, an ISO plus additional evidence of prior treatment that has been denied up until now could be enough to support it, right?
Yes, especially in this case. A lot of the case law does not support the suspension based on the ISO alone because there can be a lot of information that may not be accurate on those. However, in this case, we also had the claimant's testimony at the initial hearing that she denied any prior neck treatment, which was directly contradicted by her doctor's testimony, who testified that she did in fact have prior treatment by him. And also we had the other doctor's testimony who said she outright denied any prior treatment. So I think that false testimony in combination with not being forthcoming about her prior treatment to her other doctor really added to this argument.
And with that, the judge was able to suspend benefits?
Correct.
Perfect. So that's a great win. And I guess just to wrap things up, basically the idea is you raise fraud, there's going to be a continuation for a fraud trial 9 times out of 10, depending on the facts. In such a case, you can make an offer of proof in support of your fraud claim to also support benefits being suspended in the interim. I mean, that's not what this case is about specifically, but if you have surveillance, you might be able to offer like a slightly redacted portion of the surveillance just to show that you do have some video of the claimant. Obviously, you're not required to produce the full materials until after the claimant testifies. Otherwise, they can tailor their testimony to match the surveillance footage. But that could be one way that you could get benefits suspended. Or as in Melanie's case, if it's more based on denial of prior treatment, if you can couple an ISO with, doctor's testimony or medical records that you obtained via subpoena to show that there was prior treatment, that could be sufficient to get benefits suspended. So that's a great win, Melanie. Thank you for coming on here today.
Thank you.
We'll be back next month with more wins for episode 26. If you're interested in any more of the LOMAD webinar series, including Melanie's Minutes, please subscribe to our YouTube channel. Thank you.
Thank you.